Good afternoon, everyone. Good afternoon, everyone. My name is David Agdelia, the current president of the American Constitution Society here at the Maurer School of Law. Thank you for joining us today. We're pleased to welcome Professor Sanders and Professor Conkle for a talk about the upcoming Supreme Court term that's set to start October 7th. Before we start, I'd like to tell you a little bit about our distinguished panelists. Professor Sanders teaches constitutional law, family law, constitutional litigation, conflict of laws, and seminars on constitutional interpretation and judicial review here at Maurer. His scholarship focuses on questions arising out of the 14th Amendment's guarantees of equal protection and due process, with a special focus on issues affecting LGBTQ persons and same-sex couples. Professor Sanders practiced for 4 years with the Supreme Court and Appellate Litigation Group at Mayer Brown in Chicago, where he became the firm's most junior attorney to present a U.S. Supreme Court brief in a paid client matter. In addition to his scholarship and teaching, Professor Sanders has participated in groundbreaking litigation. On behalf of the Human Rights Campaign, he co-authored an amicus brief to the Supreme Court in Obergefell v. Hodges, which established a nationwide marriage equality for gays and lesbians. He's represented the ACLU, the American Association of University Professors, and groups of scholars and scientists as amici curiae. Did I pronounce that right? First time. In the U.S. Supreme Court, 2 federal courts of appeals, and 3 state Supreme Courts. Professor Sanders has appeared in New York Times, the Huffington Post, and SCOTUS blog, and has also appeared on MSNBC and public radios To the Point, as a regular legal analyst for Bloomberg News, and is frequently quoted by print and online news media about matters of the Constitution. Professor Dan Conkle, our next panelist, has been a member of the faculty since 1983. Professor Conkle teaches constitutional law, the First Amendment, and law of religion. His research addresses constitutional law and theory, religious liberty, and the role of religion in American law. His most recent book is Religion, Law, and Constitution, published in 2016. Professor Conkle has authored many works and has been honored for his achievements both within and outside law school. He's a 2-time recipient of the Leon H. Wallace Teaching Award and has won the Gavel Award twice. He's received 6 faculty fellowships for outstanding scholarship. In 1999, he was named the Robert H. McKinney Professor of Law. He retired from full-time teaching December 2017, but continues to be involved in the law school community. So, without further ado, I'll hand it off to our panelists.
Okay, great. Thank you, David. So, thanks for your interest. Thanks for being here. The way we're going to do this is I'm going to start out very briefly talking about just a set of about half a dozen cases that we're really not going to spend any further time on, but just to kind of put them on your radar screen to let you know of kind of the breadth of what the court is doing this term. And then Professor Conkle and I are going to use most of our time. Professor Conkle is going to talk about somewhat in depth about 2 cases that we've chosen that we think are just particularly interesting and significant, one having to do with the religion clauses and one about the Second Amendment. And then I will come back and talk about cases on the court's docket concerning DACA, the Deferred Action for Childhood Arrivals Program, and a trio of cases that presents the question of whether federal sex discrimination law also protects against discrimination on the basis of sexual orientation and gender identity. But let me first give you the also-rans, just to show, and actually a lot of these have to do with criminal procedure in one way or another, which many of you will study. I'm going to read it from here. So this case, Kaler versus Kansas, the court is going to decide whether a state can abolish the insanity defense or whether the 8th and 14th Amendments require that the insanity offense be available. A case called Ramos versus Louisiana, whether the 14th Amendment fully incorporates the 6th Amendment guarantee of a unanimous verdict. From con law, you have learned, or you will learn, that the guarantees of the original Bill of Rights were only understood to apply to the federal government. And through a series of cases over the 20th century, the court did what was called incorporation, using the 14th Amendment to apply those Bill of Rights guarantees to the states as well. Most of the things in the Bill of Rights, the First Amendment, the Fourth Amendment, the Second Amendment, Amendment, the biggies. It's well established they are incorporated. Last term, the court took an interesting case from Indiana, which incorporated the excessive fines, the guarantee against excessive fines in the Eighth Amendment, applied that to the states. That had been not incorporated. And one of the few things in the Bill of Rights that hasn't yet been incorporated is the Supreme Court has interpreted the Sixth Amendment in federal cases, the jury guarantee, to require a unanimous jury. It hasn't spoken to whether states are held to account to that guarantee or not, and that's what this case tees up. A case called Kansas versus Glover, whether an investigative stop under the Fourth Amendment, whether it's reasonable for an officer to suspect that the owner of the vehicle is the one driving the car, or whether the person driving the car is the owner of the vehicle. Is that a reasonable assumption, absent any information to the contrary? A few more cases. Hernandez versus Mesa, whether when plaintiffs allege that a rogue federal officer has violated Fourth and Fifth Amendment rights and there's no other legal remedy, whether the federal courts can and should recognize a damages claim under Bivens. Okay, that's a mouthful. It probably doesn't make sense to a lot of you. The background briefly is that a federal statute known as Section 1983 allows you to come into court and sue for monetary damages if a state or local official has violated your constitutional rights. If you can quantify the damage that's been done to your First Amendment rights or your Fourth Amendment rights or your Eighth Amendment rights, you can actually get not just injunctive relief but damages. The court, for a number of years, going back to the 1960s, has applied the same principle to the federal government as a result of this case called Bivens. But there's actually no statute that allows you expressly to come into court and sue federal officials for money damages when they violate your constitutional rights. The court has in recent years gradually been shrinking back the application of this Bivens rule because it's a judge-made remedy as opposed to a statutory remedy. And so this case asks whether in this case where there is no other remedy available, the courts under Bivens regarding a federal agent should allow someone to get monetary damages. Okay. A death penalty case. Some of you are interested in death penalty litigation. McKinney versus Arizona, whether the Arizona Supreme Court, and this is applicable to cases in other states as well, was required to apply current law when weighing mitigating and aggravating evidence to correct a previous decision on a death sentence. So the issue is, does the old law apply that was in place when the court first considered the appropriateness of the death sentence, or is the court now required to use law that may have been changed and updated in examining the appropriateness of a death sentence and resentencing a convict? And I didn't give you the names, but since many of you here are interested in intellectual property issues, that is also something before the court. There are 6 intellectual property cases. I've been reading the people who are very into intellectual property. This is a big year for Supreme Court cases, and it's exciting to IP folks that there are 6 cases presenting interesting issues, 2 each in patent, trademark, and copyright. So again, those are interesting cases we wanted you to be aware of to get some appreciation of the scope of what the court is up to this term. And now Professor Kunkel and I will both focus on a little more in-depth on each a couple of sets of cases.
Thank you. Just one further comment. The Supreme Court has not yet fully filled in its docket for the current term. So there may be additional cases that might be as significant as these listed and maybe as significant or more significant than the ones we have on our agenda to discuss right now. Among other things, you may have noticed there's some activity in Washington, potential impeachment of the President of the United States. At least I've heard that might be in the works. There are subpoenas being issued. If those subpoenas are not honored, there could be attempts to judicially enforce those subpoenas. There could be expedited review heading up to the Supreme Court. So lots of things could happen that we're not able to talk about right now because they haven't happened yet. 2 cases that I want to focus on, and Professor Sanders and I suggested that folks who have questions or comments hold them till we're both done so we have plenty of time to make sure we both get out what we want to say and then have questions after we both have made our initial presentations. The first case is a Second Amendment case from New York City. It's called New York State Rifle and Pistol Association versus the City of New York. It is scheduled to be argued in early December. It's a case that challenges a New York City gun regulation that says if you have a so-called premises license for your gun in New York City, you can keep your gun at home. You can transport it from your home only within New York City, within the confines of New York City, to a shooting range. You can't take it outside the city of New York. And in particular, the challenges are objecting to the fact that they cannot take their guns to shooting ranges outside the city limits, nor, in the case of one challenger, he can't take his gun to a second home that he owns elsewhere inside the state of New York. This case also raises significant justiciability issues, which I'll come back to momentarily, with New York City contending that the case is moot. Second Amendment provides as follows: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. One might think that if you read that well-regulated militia part of it, the Second Amendment would in fact be confined to that setting. The Supreme Court seemed to think so as well until 2008, when it issued the Heller decision, ruling 5-4 that the Second Amendment, despite that introductory language, in fact confers an individual right to keep and bear arms outside the military setting. 2 years later, in 2010, and this gets to the incorporation doctrine that Professor Sanders mentioned, the Supreme Court, in a case called McDonald versus the City of Chicago, ruled that the Second Amendment, as interpreted in Heller, was in fact incorporated and would apply to states and subdivisions such as the City of Chicago. If you haven't read Heller, I would urge you to read it. It really tests the viability, to my mind, of an originalist approach to constitutional interpretation. You can read, if you wish, the majority opinion by Justice Scalia, who regarded that opinion as one of his best, or you could read the dissenting opinion by Justice Stevens. You might like that one. They both are heavily historically oriented, claim to be relying on originalism, reaching diametrically opposite results in terms of whether the Second Amendment, in fact, confers an individual right to keep and bear arms outside the military setting. Query whether originalism is up to the task of resolving an issue of that sort, and whether instead the justice's own ideology or personal values may be doing a lot of the work. In any event, in both Heller and McDonald, the holdings were narrow in that in both cases you had regulations, District of Columbia in the one case, Chicago in the other, that essentially banned the possession of handguns even in one's own home. And the Supreme Court concluded that possession of a gun for self-defense in the home is especially important under its interpretation of what the Second Amendment required. Having said that, the court in Heller also emphasized, and I'm quoting to a significant extent here, that the Second Amendment right is, quote, not unlimited. The court identified a list of presumptively lawful regulatory measures, including, quote, long-standing prohibitions on the possession of firearms by felons and the mentally ill, laws forbidding guns in sensitive places like schools and government buildings, and conditions and qualifications on the commercial sale of firearms. Likewise, the court said the government could ban dangerous and unusual weapons. And the court said similar things in the follow-up case of McDonald. What's more, in neither case did the court indicate a general method of analysis, such as strict scrutiny, intermediate scrutiny, or anything else. So that was McDonald was 9 years ago. Since then, the Supreme Court, until the current case, denied cert in multiple cases, dozens of cases, leaving Second Amendment challenges, and there have been many of them, to be resolved by lower courts, with some mixed results. Generally speaking, gun regulations have been upheld by the lower courts. The method of analysis has varied to some extent in the various circuits. The typical method, though, seemingly the dominant one, is that which was applied here by the Second Circuit, which basically conducted a two-step analysis, asking first, does the regulation restrict conduct that's protected by the Second Amendment? That is the Second Amendment implicated? And then, if so, the court basically said we'll decide the level of scrutiny, whether strict scrutiny or intermediate or even rational basis or something like it, depending upon the degree to which the regulation, in fact, burdens Second Amendment rights. And so, in essence, you ended up with a different, in the Second Circuit at least, a different standard review depending upon how substantial or severe the burden on Second Amendment rights was deemed to be, paying special heed to what the Supreme Court regards as the core of the Second Amendment, self-defense in the home. So in essence, what the court said in the pending case, the Second Circuit, is that the law did not impose, in its view, a substantial burden on Second Amendment rights. Basically, the court said, hey, New York City has 7 shooting ranges inside the city limits. There's 1 in each borough. What's more, if you want to go and practice at a different shooting range, you can rent a gun there. You could buy another gun if you want to. They'll probably loan you a gun. And for the challenger who had the second home, the court also said, buy another gun. The fact that you have to pay something to have a gun at your second home is not a significant or substantial burden on your Second Amendment right, even in the setting of the home. The court hedged its bets, though, with respect to the challenger who had the second home, saying that even if it was not a substantial burden on Second Amendment rights, it did seem to implicate potentially this core right of self-defense in the home. So the court essentially, in the alternative, went on and invoked intermediate scrutiny, but said that the intermediate scrutiny was satisfied based on the city's interest in safety and crime prevention. And I think it's fair to say, if you read the opinion, the intermediate scrutiny was relatively lenient. In essence, the court said, among other things, that, quote, as long as the defendants produce evidence that fairly supports their rationale, the laws will pass constitutional muster, seeming to apply a balancing analysis, basically saying, again, a little bit later in the opinion, the law, quote, makes a contribution to an important state interest in public safety substantial enough to justify the insignificant and indirect costs it imposes on Second Amendment interests. So basically, and I think that's more or less in keeping what many of the other lower courts have done, if the Supreme Court reaches the merits, much speculation would suggest the Supreme Court would reach a different result on the New York City regulation, might chart an easier path to strict scrutiny, or at least a stronger version of intermediate scrutiny, if in fact the court reaches the merits. One significant change in the Supreme Court most recently would be the Kavanaugh appointment to the Supreme Court, replacing Justice Kennedy. Who knows why the court has not granted cert over the last 9 years, now has granted cert. In any event, much speculation shared by New York City and the state of New York that they're going to lose in the Supreme Court, and that leads us to the justiciability issue. New York City, soon after the Supreme Court grants cert, amends its regulation, seemingly thinking, hey, we're going to lose in the Supreme Court. The state of New York, the legislature passes a law essentially requiring New York City to have the new amended regulation that in fact says it's okay to take your gun to a shooting range elsewhere in the state of New York. It's okay to take your gun to your second home, seemingly eliminating the challenge by the challengers by giving them all the relief that they have sought. New York City then responds, or shortly after the amendments are made to the regulations in the state law, sends to the Supreme Court a suggestion of mootness, saying this case is moot, you should dismiss the case as moot. Conversely, the challengers have said, no, wait a minute, there's an exception to the mootness doctrine, among other things, for voluntary secession. So sometimes the Supreme Court has said a case that otherwise appears to be moot can nonetheless be decided on the merits on the ground that the defendant has voluntarily ceased the challenged activity but could turn around and do it all over again once we dismiss the case as moot. The problem here for New York City is that under that new state law, New York City could not itself reimpose the old regulations. Maybe it could get New York State legislature to change the regulations again. In any event, I think there's a very strong argument that this case, in fact, is moot. a question that the Supreme Court, by coincidence, supposedly has on its conference agenda for today, to consider whether or not the case is moot, whether it in fact should dismiss the case as moot, whether it should remand to the lower courts to take up the mootness issue, whether it should just invite briefing on the mootness issue, or how, in fact, to proceed. One final footnote on the mootness issue is that in the middle of August, and if you haven't read this, I'd urge you to do so because it's quite remarkable. There was a remarkable amicus brief submitted by United States Senator Sheldon Whitehouse, joined by 4 other Democratic senators, that maybe vitriolic is too strong a word, but maybe not, basically says to the Supreme Court, if you don't dismiss this case as moot, you will be showing the entire world, if they're not already aware, that you're nothing but not quite partisan hacks, but basically this is a political body, not a judicial body, if you in fact duck the mootness issue or somehow find a way to reach this case on the merits. Whether that's sort of a brief, sort of an in-your-face to the Supreme Court is useful advocacy, or whether instead the Supreme Court might resent it, might get its back up, who knows. In any event, a rather remarkable brief of a sort I've at least never seen before. Okay, so that's the Second Amendment case. The second case I want to talk about is a case that raises challenges under the religion clauses of the First Amendment to a state constitutional provision from the state of Montana that precludes the extension of student funding to private religious schools. The religion clauses, which also have been extended to the states by way of incorporation, forbid, quote, or prohibit, quote, laws respecting an establishment religion or forbidding the free exercise thereof. So you have typically understood establishment clause, which forbids the government from sponsoring religion, supporting religion in certain respects. The free exercise clause, which protects religious exercise from being burdened by the government. Cases, especially under the Establishment Clause, have included challenges to things like religious exercise in the public schools, government sponsorship of religious symbolism. Notable case last term in which the Supreme Court approved the inclusion of a Christian cross in a World War I war memorial in the District of Columbia area. The current case, though, deals with another longstanding area of debate, and that is funding. The use of government tax dollars to fund religious private schools or other religious entities or religious activities. What is at issue here, the Montana program is not a voucher program, but it's usually it tends to be thought of as something like a voucher program. In other words, I should say, to describe this program in more detail, basically taxpayers in Montana can get up to a $150 tax credit, dollar for dollar, for contributions that they make to student scholarship organizations. Those student scholarship organizations, in turn, then can provide scholarships to students attending private schools, religious or non-religious. But the fact of the matter is, in Montana and elsewhere, most private schools are, in fact, religious. In any event, the program, as adopted by the state legislature, specifically said we want to include religiously affiliated schools as well as non-religious private schools. So the program, in the parlance used by the Supreme Court, is a neutral program of aid as adopted, one that would extend to religious schools, but not targeting religious schools. It would extend to religious and non-religious schools alike. So far, so good. But the Montana Department of Revenue decided that it, in fact, could not extend this program to funding for students attending private religious schools. Why? Because the state constitution of the state of Montana precludes, quote, direct or indirect aid to any church, school, or other institution controlled in whole or part by any church, sect, or denomination. Okay, so the state constitution bars direct or indirect aid to religious schools, or so at least the Department of Revenue concluded. The case goes to the Montana Supreme Court, challenged by parents whose kids are in private religious schools saying we want the benefit of these scholarships. The Montana Supreme Court essentially agrees with the Department of Revenue, saying, yeah, the state constitution precludes this aid. It would violate the state constitution to include the religious schools, so that the program extended to religious schools, in fact, does violate the state constitution. But there's a fly in the ointment here as well, because in essence, the Montana Supreme Court says, but the Department of Revenue had no authority to change the statute. The Department of Revenue did not have the authority to do what the legislature did not want it to do, which was to exclude religious schools. So the Montana Supreme Court said, tell you what we'll do. We'll invalidate the entire program. Nobody can get these scholarships, whether it's at a religious school or a non-religious school, which have led some, including the state of Montana, to say, well, isn't this a mootness problem, or at least a problem in terms of eliminating the challenge, because under the Montana Supreme Court ruling, there's no longer any discrimination against any religious schools because nobody gets the funding, and this is essentially a way by which to avoid the challenge under the First Amendment, which is that the state is unconstitutionally discriminating against private religious schools in violation of the Free Exercise Clause. I personally don't think that that argument works. In other words, I think that here, unlike, for example, in the gun rights case, if the challenging parents win the case, the Supreme Court will rule that the Free Exercise Clause precludes the state from discriminating against religious schools in the scholarship program. The Montana Supreme Court on remand, presumably, would enforce the law as written by the legislature, and the parents whose kids are at religious schools would be henceforth eligible for the scholarship. So I don't think the relief is eliminated, and I don't think a state Supreme Court can immunize a challenged state policy from federal review by fashioning a remedy of the sort attempted here. The state Supreme Court still was relying upon a state constitutional provision, finding that that provision requires the state, in this particular funding context, to discriminate against religious schools. So the basic question is, well, it's actually twofold. I mean, back in the day, back in the 1970s and the 1980s, there would have been a good argument that the First Amendment, in fact, requires Montana to do what the Montana Supreme Court said its state constitution required. Why? Because the establishment provision of the U.S. First Amendment was interpreted to require a strict separation of church and state, by which neither the federal government nor any state could, in fact, extend a general program of funding to the extent that it went to a religious institution like a religiously affiliated school. Perhaps the most radical example of this, or the most extreme example of this, was a case in which the Supreme Court said that a state could not provide funding to help private schools maintain their physical facilities because, after all, if it's a religious school, they may pay their custodian, and part of his job may be to sweep out the chapel. And we're not going to let any money drift in any way to a religious destination. That doctrine is gone. That doctrine, in more recent decades, has been replaced by an Establishment Clause doctrine that is extremely lenient with respect to permitting states to extend neutral funding programs to religious beneficiaries as long as they are neutral. In other words, as long as they go to religious and non-religious beneficiaries, generally speaking, the Supreme Court has said that's okay, including, in a 2000 case, approving school voucher programs that permit parents to use the vouchers at religious schools as well as private non-religious schools. The issue that is now presented, really beginning in the last 15 years or so, is whether a state is permitted to do what Montana did. Can a state permissibly decline to provide funding even when the Establishment Clause of the First Amendment would permit that funding under cases like the Supreme Court's voucher program? In essence, the challenges have been made to constitutional provisions of various states, like those of Montana, which have strong prohibitions on funding for religious institutions and religious schools. The challenges are made basically on the Free Exercise Clause of the First Amendment, saying that for a state, even under a state constitution, to engage in a discriminatory denial of funding against a religious school or a religious institution itself violates the Free Exercise Clause, therefore the state can't do it. In other words, the argument now has become not merely that a state is permitted to extend funding to religious schools and beneficiaries. The argument now is a state is required by the Free Exercise Clause to extend that funding. If it extends to secular beneficiaries, it must, in fact, extend to religious beneficiaries as well. In the first go-round on this issue, a case called Locke versus Davey in 2004 suggested in a 7-2 ruling by Chief Justice Rehnquist that states, in fact, had considerable discretion to deny funding if they wished, even if the Establishment Clause would permit them to provide it. In that case, a ministry student named Joshua Davey had been denied funding under a otherwise generally available scholarship program. The state of Washington has a state constitutional prohibition, sort of like Montana's. The state of Washington said, we can't give money to a ministry student. The Supreme Court said, well, you could if you wanted to, as far as the Establishment Clause is concerned, but you don't have to. There's room for play in the joints such that a state can be more restrictive in its funding than the Establishment Clause would permit. So the Supreme Court says it's okay. States have discretion to deny funding if they wish, at least in the context of Locke versus Davey. Fast forward to 2017, the Supreme Court, by another 7-2 vote, goes the other direction in a case called Trinity Lutheran Church, where the state of Missouri had refused, again, citing its state constitutional provision, had refused to extend a grant to a church for resurfacing its playground for the church nursery or preschool. Why? Because it was a church. The state of Missouri said, we can't fund churches, and this is for a playground to provide safety, but too bad, churches cannot get funding because of our state constitution. The Supreme Court 7-2 says, you cannot do that. That is discrimination against a church because it's a church. That violates the Free Exercise Clause, and your state constitution has to give way to the extent that it would, in fact, seemingly require that kind of discrimination. The result was 7-2, but there was a footnote by Chief Justice Roberts speaking only for a plurality. Footnote 3, not yet as significant as the famous Caroline Products footnote 4, but footnote 3 said this. This case involves express discrimination based on religious identity. With respect to playground resurfacing, we do not address religious uses of funding or other forms of discrimination. So the question is, if you think about the funding in the Montana case, the funding is for tuition support, not clearly confined to something as secular as a playground. Is that more like Locke versus Davey? Ministry studies? Is the state free to deny the tuition funding like it did in Locke v. Davey? Conceivably. I think more likely the Supreme Court will will limit Locke and will in fact push further in the favor of religious equality. I'm guessing the result will be to in fact insist on equality in this setting, that the funding in fact has to be required, otherwise it would violate free exercise. Final footnote on the case is that one of the advocates as amicus in this case supporting the challengers is Joshua Davey. Joshua Davey, the would-be ministry student, became a lawyer, files an amicus brief in the case saying, hey, I know what's going on here, and I think that the funding should, in fact, be constitutionally required. I'll take questions after Professor Sanders.
So the two issues I'm going to talk about are actually neither are issues of constitutional law. This is the American Constitution Society. Professor Conkle and I both teach con law, but often that just becomes a sort of shorthand for interesting stuff before the Supreme Court. And we just decided in the grand scheme of things, important cases, cases this audience is likely to be interested in, that these cases were worth talking about. So the court has before it three challenges which have been consolidated to the Trump administration's decision to end the program known as Deferred Action for Childhood Arrivals, or DACA. DACA was established by the Obama administration. It allowed what are now 700,000 to 800,000 undocumented immigrants, frequently called dreamers, who'd been brought to the United States as children by their parents to apply for protection from deportation and for permission to study or work here. These are people who had only known this country as their only home. In creating DACA, the Obama administration was arguably doing what administrations of both political parties have done for a long time, and that is exercise discretion Congress has given to the executive branch to set priorities on deportations, about how to best enforce the nation's immigration laws. We don't have the resources to deport every last person in this country who may be undocumented, so we can prioritize criminals and people who are doing other bad things and give a much lower priority to children who were brought here, where this is the only home they've ever known. But in 2017, the Trump administration revealed plans to terminate DACA. And in ordering the Department of Homeland Security to end the program, then Attorney General Jeff Sessions cited little more than what he called legal and constitutional defects behind DACA. There have been 3 lower federal court decisions against the Trump administration decision to end DACA, including a Ninth Circuit decision, and that's what's before the court right now. The issues in these cases, the legal issues, are whether the Trump administration's decision to end DACA was consistent with the Administrative Procedure Act, which is something you would learn lots about if you take admin law at this law school. The Administrative Procedures Act prevents agency action that is arbitrary, capricious, and abuse of discretion or otherwise not in accordance with the law. The lower courts in this case ruled that the DACA decision should be set aside because it was arbitrary and capricious, that it was not the process of rational decision-making. The principle here in administrative law is that when an agency, rather than Congress making laws, when an agency makes a policy, propagates regulations, when an executive branch agency effectively makes law, it is supposed to include an analysis of the decision to make a particular change and an explanation of why it's doing so, especially if people have come to rely on a previous interpretation, that is, have come to rely on DACA. And so the plaintiffs in this case argue that the government's decision to end DACA did not meet this requirement, that the rationales the Trump administration offered were simply bare bones. The Trump administration makes 2 arguments. One, it says the decision to end DACA is not even judicially reviewable because it is a quintessential policy where the executive branch has discretion. And so if the Obama administration's decision to defer these particular deportations represented essentially a sort of prosecutorial discretion, the executive branch has to prioritize who should be deported and determine how best to enforce our immigration laws. The Trump administration is arguing that, well, then the decision to wind down that same policy is a quintessential example of the kind of discretion that executive branch agencies are entitled to, that this is not an invasion of someone's legal rights, it is a discretionary policy judgment. But the Trump administration says, second argument, even if it is judicially reviewable, even if the Administrative Procedures Act does apply here, that it had legal and reasonable reasons for ending DACA. And it cites a number of things. It says it believed that keeping DACA in place would be, quote, sanctioning an ongoing violation of federal immigration law by 700,000 aliens. It also noted that the Fifth Circuit, the federal court appeals court in Texas, had struck down 2 related Obama administration policies that protected, that deferred action for the immigrant parents of children who had been born here, where the children were citizens, and so the Obama administration decided it would be a good idea to deprioritize the deportation of their parents, even though they were undocumented. Trump administration says in light of the DACA program's, quote, legally questionable provenance, plus announcements from various states that they would challenge DACA, the government believed the best course was to go forward with an orderly wind down on its own terms rather than take the chances that the program could be abruptly shut down by a federal court order like the one in Texas. The Trump administration also says it made the decision that it would be better to do if we're going to have a DACA program, it should be something that's congressionally approved. President Obama himself, when announcing DACA, said that the program was only intended as a temporary stopgap measure. Instead, the Trump administration says it has now opted to return to a pre-DACA system of reviewing requests for protection from deportation on a case-by-case basis. I do not claim to be enough of an expert on administrative law or the various justices of the court's views on administrative law to have a prediction of how this case is going to come out. In general, this is a court that has been relatively deferential toward the prerogatives of the executive branch, including in the immigration area. Witness Trump versus Hawaii, the Muslim ban case, so we'll see. The second set of cases I want to talk about is a trio of cases that it's going to be argued very soon on October 8th. Concerning discrimination against LGBTQ people. There is no federal, this may come as a surprise to some of you, there is no federal law, nothing passed by Congress, that prohibits employment discrimination against people because they're gay, lesbian, bisexual, or transgender. A bit less than half of the states have such laws. Indiana is not one. And so there is a lot of underprotection of employment discrimination when it comes to gays, lesbians, bisexuals, and transgender people. What we do have as federal law is an emerging patchwork of protections from a number of lower federal courts that have taken federal sex discrimination law and extended it to sexual orientation and gender identity. Title VII of the 1964 Civil Rights Act, passed in 1964, says it shall be an unlawful employment practice for any employer to fail or refuse to hire or to discharge an individual or otherwise discriminate with respect to compensation, conditions, privileges, employment because of the individual's race, color, religion, sex, or national origin. So the issue this cases really present is how much work can that word sex do in the 1964 Civil Rights Act. These cases involve a Second Circuit case involving a gay male skydiving instructor who was fired from his job, he says, because he was gay. An 11th Circuit case involving a gay male county employee in Georgia who was fired after he started playing on a gay softball team, and his public employer disapproved of that. And a 6th Circuit case from Kentucky involving a transgender woman who was fired from her position as a funeral director because her employer did not like the fact that she had undergone a gender transition and was now presenting as a woman. So what are the arguments that a law that prohibits sex discrimination, like Congress passed almost 2 generations ago, could also be thought to cover sexual orientation or gender identity? Well, Title VII many years ago by the Supreme Court was interpreted to outlaw mistreatment on the basis of sex stereotypes. This was a case that involved an accounting firm that had basically had denied a partnership to a woman because she didn't dress femininely enough or wear makeup. And the court said, no, that's a gender stereotype about how a woman has to behave and has to dress and has to look. And if an employer acts on the basis of that, that is sex discrimination. That's covered by Title VII. And so the reasoning behind these cases goes is that being gay or lesbian is sort of the ultimate failure to conform to a sex stereotype. Just like the accounting firm that denied promotion to a woman who wasn't feminine enough, an employer who fires someone for being gay or lesbian is policing the boundaries of what behaviors are acceptable for men and women. A man may date a woman, but a woman is punished if she does so. That is discrimination on the basis of sex. So the argument goes in these cases that several lower courts, including our 7th Circuit, which covers Indiana, have accepted. A similar argument goes for someone who was born male and has transitioned gender, usually with the assistance of counseling and sometimes medical treatment, and now identifies as a woman, or vice versa. If an employee, as in the case of Kentucky, if an employee was born Anthony and has become Amy, and the employer fires her because he disapproves of that, well, that's discrimination that could not have happened but for the employee's sex and her failure to conform to the employer's gender stereotypes. And so you can see this Price Waterhouse case, the accounting case about sex stereotypes, does an awful lot of work. It's a sort of necessary step to get from Congress outlawing sex discrimination in 1964 to the idea today that that same law can be used to attack anti-gay, anti-lesbian, anti-trans discrimination. It is sort of mainstream statutory interpretation. It seems like a natural extension of precedent. I think we can assume that the court's more progressive justices, the four anyway, Justices Ginsburg, Kagan, Sotomayor, and Breyer, will accept this because it is fairly mainstream statutory interpretation. But I think many of us are skeptical that this reasoning will persuade the court's five-member conservative majority. At least some of those justices are likely to argue that when members of Congress 2 generations ago enacted Title VII, they could not possibly have imagined that they were protecting LGBTQ people. This is a form of analysis that looks to either the original intent of Congress or at least the original public meaning and understanding of what Congress was doing in 1964. And these sorts of originalist justices, and most of the justices we're talking about are very sort of ostentatiously originalist, reject the idea that courts may interpret words or ideas in a statute such as what it means to discriminate on the basis of sex according to contemporary common sense understandings. And I think kind of tied to that, along with that reasoning, that sort of originalist understanding, that original public meaning understanding of Title VII, also goes the argument, and we will likely hear some of these justices essentially lecturing LGBT rights advocates, look, use the democratic process. Take your arguments to Congress and ask them to update the law. Well, the problem with that is, and this is a topic that I don't have time to delve into in a lot of detail, in many ways we arguably have a counter-majoritarian political system, a political system that is not as responsive as it should be. Since the mid-1990s, supermajorities of Americans, over 80% consistently, have told Gallup they support the principle that gays and lesbians should have equal rights in terms of job opportunities. Yet Congress has consistently refused to act on that widespread, how many issues in this country do we have north of 80% consensus going back, to the mid-1990s? So law frets constantly about the proper role of judges in a democracy, and we're likely to hear talk around that issue in these cases, but that conversation assumes the existence, I think, of a functional legislative branch that behaves in a responsible and reasonable manner and is capable of living up to its responsibilities as a co-equal branch of government. I think arguably, at least on LGBT rights, maybe other things you're interested in as well, those premises just haven't held true for a long time. And so, we have to question how much weight should that use the democratic process, don't ask the courts to make social change through creative exercises of statutory interpretation, how much weight that argument should really carry. Just one last thing, and then we did want to leave some time for questions. I like those decisions, like the Seventh Circuit gave us, and like these cases before the Supreme Court. As somebody who has worked in LGBT stuff, I think, one reservation I have is they sort of get you where you want to go, but they avoid confronting the real issue. If this is a society that feels that the time has come that to declare, to use the expressive power of law, that anti-gay or anti-trans discrimination is wrongful, then, maybe we should have a statute saying so and attack the problem of homophobia and transphobia directly, rather than essentially sort of bootstrapping our way to that conclusion through the use of statutory interpretation and the meaning of sex in Title VII. So anyway, we did want to try to leave some time for questions from you, so thank you. Professor Hopkins?
Oh, sorry.
Oh.
If you have a question, this gentleman has a question right here. We'll get the mic to you so we can get on.
By the way, this is being recorded for the Maurer website, so.
Sorry.
Yeah, this is in part so the recording can hear you.
I have a pretty narrow question. Would you rank order, and if you think it can be done, between the transgender case and the discrimination? Which one is more likely to win, or do you think, or lose, or do you think they're equal?
If there's some possibility, to my mind, I think the use of Title VII related to transgender discrimination, a man who transitions to a woman or vice versa, just feels more natural, feels closer to what it means to engage in sex discrimination. I understand the sexual orientation argument, but it is that is a little more formalistic, I think. And I take it you agree.
So I know that the Obama administration defined sex discrimination to include discrimination on gender identity, sexual orientation, as well as pregnancy status. Is that before the court, or do you think the court might, talk about that in dicta in these cases, whether pregnancy discrimination is included or not?
So I think what that gets to is, besides Title VII, the executive branch promulgates lots of regulations and policies about discrimination and funding and so forth, and the Obama administration adopted the same understanding as well. These cases wouldn't formally reach that. Nominally these cases are just about Title VII. But I think it opens the door then to the possibility, if the decision is such that it seems the Supreme Court is squarely saying sex only means this, then those regulations could be in danger. However, it depends on how much the Supreme Court is looking back to 1964. I suppose an argument might be available. Well, more recently adopted agency regulations, could have a different public meaning, a different original intent than something Congress did in 1964. So it kind of depends on whether the Supreme Court focuses just on the, really delves deeply into parsing what the word sex can permissibly mean or not mean, or whether the focus is more on this, Congress knew it was doing a certain kind of thing in 1964.
Thank you.
Thank you both for that very informative talk. Professor Konkel, this one is for you. Regarding the Second Amendment line of cases, and thinking about basically how the Scalia's opinion in the D.C. case kind of really set up what the court then talked about in the McDonald case a couple years later, and then the court has just punted on everything for years since. So this New York case that's pending doesn't seem like it's that, there's an issue of mootness. It also doesn't seem like there's that big of a liberty interest at stake here. However, is there a concern amongst gun rights advocates, especially considering a lot of movements and pushes towards Congress to do something about gun legislation, that the court might use this opportunity to set itself up for the future, even further entrenching the expansion of the Second Amendment like it did previously?
Well, yeah. I think presumably the Supreme Court oftentimes, I should say, when the Supreme Court accepts cert in a case, even though it's not one of the criteria, it thinks the decision below was wrong. Maybe it is one of the criteria if it substantially departs or something like that. But in any event, I think one could assume that 4 justices who granted cert thought there was something wrong with the way the Second Circuit approached the case, including with respect to the result. I think from the standpoint of the gun rights activists, this is significantly restrictive. The idea would be that to have a gun for self-defense in your home suggests you should know how to use that gun. You should be able to practice. You should be able to go to a shooting range that is convenient to you. and maybe you live near the border of the city limits, and there's a convenient one that's very close but outside the city limits, and why should you have to go somewhere else to use that shooting range? Or if you have a second home, you shouldn't have to buy a second gun. And the regulations, which are not being contested, require the gun to be unloaded, stored separately from the ammunition, locked while you're transporting it. So I'm not sure that the folks on the Second Amendment side would be saying this is a minimal, although the Second Circuit thought so, would be saying this as a minimal intrusion. And then, to be sure, the idea from that side of the debate would be to get the Supreme Court to say something more, identify the appropriate standard review, perhaps chastise the Second Circuit for seemingly applying a very moderate or mild version of intermediate, and then come back to later challenges later. It's hard to tell. I mean, the Supreme Court set this ball rolling with Heller and McDonald, and then somewhat inexplicably, stepped out of the fray for 9 years, and there have been, I think, hundreds of challenges in state courts and federal courts. So why does it want to jump back in now? Presumably it wants to do something to at a minimum, regularize the approach of the lower courts, and perhaps more likely heighten the degree of protection provided under under the Second Amendment.
Keep them short. We'll try to work in as many as we can.
Rather esoteric question, but Kennedy wrote many of the majority opinions on LGBT issues, with Scalia and dissent. Both are off the bench now. Do you have any guesses on who takes up the voice of the court on that subject?
We also, this is an interesting point about these cases. As I said, these are not con law cases, they're statutory interpretation cases. All four of the Supreme Court's major landmark cases for gay and lesbian rights, anyway, authored by Justice Kennedy, were constitutional cases. They're cases that lend themselves to taking open textured language like words like liberty and equal protection and extending them in directions that society has sort of moved in the direction of becoming ready to accept. My recollection is Justice Kennedy on statutory interpretation issues could be a little bit more conservative. So I'm not even sure it's a guarantee that if he were on the court, he'd vote. It's not, I think his decisions in those cases were not explained so much by his desire to advance gay rights. They were driven by his very libertarian and sort of living constitutionalist vision of the 14th Amendment. So Justice Kavanaugh wrote a book, reviewed a book about statutory interpretation, praising the author. The author was the judge who wrote one of these cases in a lower court, so that is now before the Supreme Court. So we'll see what ice that cuts. And the Chief Justice. I don't know. I just don't really see any of the five conservatives being willing to go. I think they're just too invested in this idea of modesty when it comes to interpreting the will and words of Congress.
Well, regarding that case, trying to remember what I'm saying. Okay, so this is about employment. What about public accommodations and those sorts of things? How quickly will that affect those, those parts of life?
Well, so Title VII, this law we're working with, this federal law, only applies to, for sex discrimination, only outlaws employment discrimination. Another part of the Civil Rights Act of 1964 does outlaw discrimination in places of public accommodations for race, and I believe national origin and religion, but not sex. So there is no federal law dealing with places of, in other words, can you be refuse service in a restaurant or a bakery or something that's generally open to the public? There is no federal law on that for gays, lesbians, transsexuals, or sex generally. To the extent there is public accommodation law, it is state law. Now, the Democratic House under Speaker Pelosi has passed a law, I believe, that would cover both employment and public accommodations for sexual orientation and gender identity, but of course the Senate has not and almost certainly will not take that up. So that's another ways down the road, I think, that will require legislative action, probably can't be done by courts, just extending principles that already exist.
Just another quick point on the public accommodations. I don't know what the proposal says in terms of the definition of a place of public accommodation, but as I understand it, the federal law, even for race and religion, defines place of public accommodation rather narrowly as compared to many state laws. So you're talking about hotels, motels, theaters, and the like, but not any business that serves the general public. So many of the state laws, public accommodation laws, define public accommodation to basically include any business that serves the general public, so the federal definition, I think, would be one that might be contested if it extends like the state laws do.
My quick question, Professor Conkle, is about the Second Amendment. Why does the Supreme Court never look at the beginning of the Second Amendment about protection of society and establishment of a militia? They never talk about those as qualifying languages, and we know then muskets were around.
Basically, if you read the Heller opinion, Justice Scalia and Justice Stevens debate that language. Stevens says, although he provides all kinds of other historical support, if you look at that language, the beginning part of it, it's plain that this is about militias. It's not about an individual right to keep and bear arms. Justice Scalia says, oh, wait a minute, that's just what he calls prefatory language. And that language basically is simply describing the reasons why the framers decided to adopt this provision. What he calls the operative part is the right of the people to keep and bear arms shall not be infringed. So basically, that's just a little bit of whiteout. We don't have to pay too much attention to that first part of the Second Amendment.
So I would like to thank our distinguished panelists for coming out today. Also taking the time, because these are some very dense and complex issues. So thank you so much. And also thank you to the Graduate Colloquium for co-sponsoring today.